After long legal battle between resident doctors and the federal government, Industrial Court today has ordered that resident doctor return back to work and resume duty in the interest of Nigerians, because there is no amount of money that can be used to purchase life of any citizen. But the lawyers of both parties has this to say.
Well, what has happened today is that the court first delivered a ruling on the order of priority of taking the claimant's application for interlocutory injunction and our preliminary objection. We argued that under the law, preliminary objection takes precedence over any other application, and particularly it takes precedence over the interlocutory application for injunction by the claimants. The court overruled us and held that the court would take the interlocutory application for injunction first, and that our notice of preliminary objection would be taken along with the judgment on the substantive suit. We also drew the attention of the court that we have filed an application for stay of execution of the order, and that order ought to be taken first before entertaining the interlocutory application. The court disagreed and went ahead to take the interlocutory application for injunction by the claimants, and ordering members of our client, the defendant, to resume work immediately. On this note, we would discuss with our client, the defendant, and take further instructions whether to appeal the ruling or not to appeal the ruling, and taking any other necessary legal processes. No, we are not court. We are not court. So we cannot order the client. But as lawyers, no lawyer would say disobey court order. But the law also provides for appeal against the order, which our client would consider. And within that context, the legal battle would continue. No lawyer would say disobey court order. No lawyer. But we also explain to our client the legal openings they may also explore to set aside the ruling. So depending on the instruction we have from our client, we would follow their directives. No, that was, with due respect to the learner's sake, as I pointed out to the court, that was a misinformation, because the addendum prepared by the government, by the claimants, which was given to our client yesterday, that addendum recognizes that the timelines in the memorandum of understanding signed on the 21st day of August this year, those timelines have lapsed, and that there will be a need to set new timelines. So their addendum sought to set new timelines within which the terms in the MOU would be implemented. Similarly, in the proposed terms of settlement, our client also set new timelines, which all parties ought to have considered. But the minister did not even come out of his office to meet our client yesterday. The minister, according to our client, only sent his aides to our client, the president of our client, that they would be consulting their lawyers. So we expected that in the interest of the masses who have no means of going abroad for medical care, the government ought to have been interested in looking into the new timelines. No new issue at all. No new issue at all was introduced. There were issues which the MOU said ought to have been implemented immediately. There were issues which the MOU said ought to be implemented within 1 week. Therefore, if the MOU was signed on the 21st day of August, the 1 week timeline lapsed on the 28th day of August. New timeline ought to be set, but they were not prepared to enter into negotiations on the new timelines. Rather, they chose to unilaterally determine new timelines which they want to impose on our client. And we pointed out that does not conform with the modern trend of industrial relations. Modern trend of industrial relations and the law of this country support collective bargaining, collective agreement, not unilateral imposition of terms.
Don't see it that way. I see it as a win-win situation on both sides. You recall that on the last adjourned date, which was on the 15th of this month, on Wednesday precisely, the courts had adjourned to deliver its ruling on the priority of the pending applications before it. We did inform the courts that parties would love to explore further settlement of this matter. And the Honorable Minister for Labor and Employment, having spoken with the lead counsel for the defendants, came up with an addendum to the memorandum. If you recall that on the last adjourned date, we told you that they had agreed to sign that MOU. So we basically adjourned to sign that MOU, only for the defendants to come up with entirely different agreements, which introduced new issues in the MOU, which they had agreed to just go back from court and sign. So practically they walked out of that agreement, and as was reported in the press, I think yesterday, they walked out also on the meeting with the Honorable Minister. So when we came today, the matter for today was to report settlement, or the court will proceed to deliver its ruling and take the applications pending. So parties we added them on our own parts and on the part of counsel for the defendants. They considered that negotiations had broken down, and their lawyers specifically said they were prepared to match us on the processes before the courts. That were his expert words. And in view of that, the court proceeded to deliver its ruling and said that the issue of jurisdiction which they had raised, in line with case law, judicial authorities to that effect, and the provisions of the rules of the courts, that in matters of originating summons, when facts are not in dispute, that the preliminary objection should be taken together with the substantive application. And also, being that this is a vacation court with limited time set up to take urgent applications, that the court was minded to take our notice of motion of notice for interlocutory injunction. So the court took our application, motion of notice, to restrain the defendants from continuing with the industrial strike and also to compel them to go back to work. The counsel for the defendant respondents opposed that application, and the court, in its ruling, agreed with us on the issues canvassed and specifically made an order restraining defendants from continuing with the strike and also compelling them to go back to work. For me, and also the court also further asked parties to also continue to negotiate while they are at work. So for me, it's not a win-loss situation. It's rather a win-win situation, both for the parties and both for the country. So I think it's a welcome development. And it's not urgent. They don't have any issue with that. That's not what happened. What happened is that the MOU which they refused to sign, which was dated 20th of August, there were certain things that we agreed on our own part as federal government to do within 1 week. That was as far back as 20th of August. Of course, 1 week advance is there. So what we basically did was to now say 1 week from today. So that is not a substantial alteration, but they were not prepared. As from day one, they were never prepared to sign.
Bimiga Olamiko, GTV Africa.